Yes, Judge.
Okay, you can make your announcement, and or Carol, you can make your announcement as well.
Jay Patel on behalf of Shirley Meyer, 23CF2740, before the court on defendant's motion to declare costs.
And Priscilla De La Torre on behalf of the state.
And I've got Mr. Earl from the JAC's presence as well.
James Earl on behalf of the Justice Administrative Commission. Thank you.
Mr. Earl, can you tell me what the JAC's position is on the motion?
I've read your response, but just put it on there.
It's a two-pronged response to you, Your Honor. This is an IFC motion for indigency for costs, which requires, in this case, a two-prong analysis by the court. The first prong is similar to the process that the clerk would have done if there had been a request for a court-appointed attorney.
Mr. Earl, can I stop you for a second? Just, you object to it.
You object to it, sorry.
Okay, no worries. I'm going to let him put on his motion. I'll certainly let you respond. I just wanted to make sure it was clear that y'all had concerns. And then the state, I'm assuming, doesn't have any concern one way or the other.
We don't.
Okay, Mr. Patel, go ahead with your motion.
Thank you, Judge. Before the court on a motion to declare my client indigent for costs, it appears that the JAC acknowledges that procedurally we've done everything correct. It's just that their contention is one based upon my fee, and because of that, and that she makes a little bit more that takes her just outside of those that presumptive indigency, and based upon my fee and her being a little bit outside, the court's got to make some findings to find that appropriate. I'm not sure if the court needs to put me under oath because evidently
I
I've
think
got to make some statements.
my concern with it, and I'll certainly let Mr. Earl give his response if he needs to, but I think she's more than a little bit outside of the indigency number. For someone with no dependents, usually it's about 2,500 to 2,800, somewhere in there. Mr. Earl, can you correct me on that?
That's correct. Let me give you the numbers just got updated by the feds. So the current poverty level for zero dependents is $15,650. So 200% of that, which would go by, is $31,300, Your Honor.
So basically, she makes 48, and the limit is 31. I just want to make sure I've got that clear.
Yes,
so
Judge.
I'm not sure what you can certainly proffer what you would tell me, Mr. Patel.
And Judge, we're asking for these costs relating to a forensic accountant to assist me in being able to present to the state a defense, and then if we have to go to trial, have that person be able to testify at trial. As it relates to my fee, it may sound a little high, but I've done these cases enough, and so I had a good understanding that this is going to take a lot of time. There were witnesses that I knew that from the very beginning that were out of county, so I'd have to travel, which we've done that. And that fee also includes the trial fee. So and that makes a fundamental difference on how we work.
I don't think anyone's debating whether or not your fee would be reasonable given your experience. It's whether or not if someone's indigent and pays that amount of a fee, that the state should pick up the tab for any costs.
And she didn't pay the fee. The fee was paid by her family. The real necessity here, Judge, is that without litigating the case, is my client didn't get the benefit of full cooperation, which she should have done before the arrest, which would have had the benefit of the state's expert, which I learned at the deposition. She comes into my office with about 3 banker boxes full of receipts. I mean, this is a situation where it's an incompetent sister that gets thrust upon my client, which is an older retired widow who, probably struggles to take care of herself. And so I think that it's more or less I think that this can be worked out, but we've got to get the numbers together. And I mean, I've never seen such numbers in such a disarray, but I have firm belief that there's credibility to it. And that's why we desperately need somebody that can put these numbers together and then be able to present them to the state
And what do you foresee as the cost of a forensic accountant for this purpose?
That I don't know. I know I've gone on the JAC website. I found a number of accountants that work under the JAC rates, so I think that the JAC rates are appropriate. I can't speculate to tell you how long it's going to take them to work with my client to go through all these numbers, but it's a significant amount of time that would be needed to go through the pluses and minuses.
How old is your client, Mr. Patel?
I learned early on to never ask a woman her age.
Read the report.
November 18, 1950.
And where is she employed?
She's not.
Why, so what's her take home? Is that
It's a combination of her of I think some Social Security, her late husband's retirement. I don't have. If you give me 1 second. There's her late husband's military retirement and Social Security.
I don't seem to understand is in the motion you've attached the application for indigency, which seems to or checked the not indigent box, but then also checked that the public defender is hereby appointed to the case. The form seems to be inconsistent, internally inconsistent, I guess is the best way to say that.
I see what you're saying.
The very bottom. All right, Mr. Earl, what's the JAC's response?
Thank you, Your Honor. It's a two-pronged response. The first part of it is, I think you've gone to somewhat, is a similar analysis as to what the clerk would do as to whether or not, based on the income and assets of the defendant, whether it should be deemed for purposes of appointment of a court-appointed counsel, Ultimately, the person must be eligible to be represented by a public defender, but otherwise has private counsel. Things that are to be considered is whether the applicant applied for indigent status with the clerk and the clerk's determination. If the applicant's income equals or is below 200%, if it's the current federal poverty guidelines. If it's above it, there's a presumption of non-indigency. In this case, it's annual income's $48,128, which puts it almost $18,000 above 200% the poverty level of $31,300. And then moving on to the presumption under 27.5D6, there's a presumption that there's more than $5,000 in attorney's fees paid, that the defendant is not indigent. In making this case, the court is to consider the reasonableness of the fee, but also the amount that a private court-appointed attorney who's being paid for by the state would receive for providing representation in this case. Thank you. Also, there's one thing on the application for indigency that needs to be cleared up, and I think that also confused the clerk looking at the attachment to the application for indigency. There's something scribbled on it about, it looks like real estate from an inheritance, and I could not figure out what that meant.
I tried to read that yesterday as well. It seems Miramar Beach, something, maybe property lot, and I don't know if it says NC lot, if that means North Carolina, Mr. Patel, inheritance of, I can't read the rest of that, but then it says divided 3 ways / her daughters. So it sounds like there may be some real estate owned, or at least some share in some real estate.
Which if it may be the case, I don't know that she can, if it's not titled solely in her name, I don't know that she may have control of that.
I think I'd have to know a little bit more about that, Mr. Patel. Because
Okay.
if she's got some assets, especially if they're, lots or some interest in a lot that is marketable, she could potentially sell that for purposes of making the cost. Again, I don't know what we're talking about for the forensic accountant. Is it going to be $500 or is it going to be, $10,000? I just don't know. And I think in the JEC's response also it said something effective because no rates were listed or potential hours to be used, that there'd still have to be another hearing as to whether or not, just to get those things actually paid in addition to a determination of indigency.
Well, Judge, I see in paragraph 9 of their, that they're objecting to any compensation rate in excess of the established rates, and we're not contending that.
I understand. I don't even know what the rate is,
Yeah.
though, and I'm not sure. Because it's kind of hard to make a judgment call as to does she have should I override the fact that she's nearly 3 times the poverty limit or poverty line when I don't even know what she has to pay potentially for a forensic account. So at this time, what I'm inclined to do is deny your motion without prejudice to revisit it. Obviously, if you can clear up the property issue to see if there's anything there, so we have that entirety of information, potentially I'm not telling you what to do, Mr. Patel, but something that might help is a more thoroughly filled out and complete application for indigency status. Because, in fact, I believe at some point the clerk's office kicked it back for being incomplete. So let's just make sure all that information is spelled out. And once I know what that is, I may reconsider. Again, when she makes 2.5 to 3 times the amount of the poverty line, and your fee was 3 times the amount of that presumption for a non-capital case, and there's the kind of specter of some potential real estate out there. Given those situations, I don't think I can grant your motion, but again, deny it without prejudice to revisit if you can shore up those things.
I will do so.
All right, thank you,
Thank you,
Mr.
Judge.
Patel. Do you have anything else?
I have nothing further. Judge, I believe that this case is set for a pretrial in February. Obviously, I'm going out of the country next month. We're not going to be able to get all this done then.
Okay.
Can I orally move now to continue the case?
Any concerns with that? Okay. How old is the case? It's from 20.
It's from,
You took it over relatively late. Is that what I?
I can't recall specifically, but we've been trying to work the case, Judge. It's just, this expert thing has delayed things. I gave it the college try on going through these numbers, and I couldn't get there.
he was arrested December of 2020. Our first hearing was January of
When did
24.
Mr. Patel take it over?
First hearing had a
No.
public defender,
Okay.
That's right. 'Cause
February of 24.
Okay. All right. I'll continue the case. What's our next pretrial? It's going to be April 28th at 9 a.m. But that's a lot of time, so I expect a lot to be done in that time.
I'll have this motion reset in March.
Okay. Perfect. All right.
Thank you, Judge.
Mr. Patel.
Thank you, Your Honor.
Thank you, Mr. Earl. You don't have anything else?
Thank
do
you. Have a good day.
All right. Thank you. All right, Mr. Madden.
John Madden here on behalf of Yaquan Anderson. Judge, may the state and I approach?
Yes.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
All right, go ahead, Mr. Madden. It looks like there's some concerns and
Your Honor,
maybe some prior issues.
the defense has some concerns on the score sheet in this case. We're hoping that that won't be an issue at the end of the day, but in case it is, we have to make sure that it's prepared correctly so that Your Honor can make a correct sentence if it comes to that. So we would be asking the court for a continuance today in order for the state and I to get together and get the documentation necessary to confirm whether or not the points that are currently on the score sheet are correct.
What's my next VOP date? After that one, I'm sorry.
I think that would be sufficient time, Your Honor. And I think at that point in time, we would either have something agreed to, or we would be ready for a hearing or a sentencing.
Let me just ask this question. The difference in the score sheet, it would still put him in a situation where he would be incarcerated past that point, right? But I don't want to be a situation where, you know, the score sheet would say he gets out if he were to plea and be sentenced according to the score sheet, he could get out in 2 weeks. I don't know what his credit is what I'm saying, because it's a VOP.
I don't
know what his
believe
past
so,
credit is.
Your Honor.
Okay.
I believe there is a difference. I don't know if it'd be that big of a difference.
I think it was basically, it was still score, but not as much.
Okay. I just want to make sure it's not a situation where he did 48 months and got put on probation, and now it scores potentially 50. So why are we, I don't want him to drag past a point where he could have been released before that date, because that's a pretty big continuance at that point.
Understood,
Sounds like
Your
it
Honor.
won't. March 27th.
And then obviously, if we can come to some sort of agreement between now
Bring
and
it in
then, we'll let the court know and see if we can bring it in earlier than that.
We're always open for a plea. All right, we'll see you back on that date, Mr. Anderson.
Thank you, Judge.
Thank you. Anything else, Mr. Madden?
Nothing else from me, Your Honor, if I
All
may
right,
be
thank you.
excused.
Yes, sir. All right. Anybody, Mr. Switek, did you want to readdress? Did y'all want to readdress? All right. This is going to be back to Mr. Nunez. 21 CF 1005.
Traz a paz das estrelas, meu amor. Quero te ver brilhar, quero te ver sonhar, como a luz do sol.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
All right. Withdraw the KPS on Mr. Nunez. Looks like we're gonna go Monday at 10:30. All right. Anybody else ready?
Ready, Judge.
All right, come on up.
Jared Sutherland on behalf of Zachary Gines for Mr. Keith Kilpatrick. With that case, I believe the prosecutor has agreed to allow us to resolve the Santa Rosa County matter prior to this one.
I'm sorry, what was the case number again?
Oh.
This was Leonard?
Nope, Zachary Gines. Yeah.
Oh, I'm sorry, I'm looking at the wrong. All right, go ahead.
I believe the prosecutor has agreed to allow us to resolve the Santa Rosa County matter prior to this case. He has been found competent to proceed in Santa Rosa County. We're just waiting on further discussions with the prosecutor in this matter.
Is he in Santa Rosa jail now?
I believe so. Yeah.
Okay, because if you look at our jail website and theirs, it looks like he's in both places.
I think he's in Santa Rosa, to my understanding, Judge.
All right, y'all don't have him, right? Steve? You don't have him? He is in another institution. Okay, so I'm assuming that it's Santa Rosa.
Yes.
Okay, perfect.
Yep.
And Your Honor, this is Ms. Berrickman's case, however, she did indicate that the inspection will continue on the VOP to Santa Rosa to resolve the failure to register that he has over there because that's really the basis.
Gotcha. All right, how much time do you think y'all will need, Mr. Sutherland?
We'd ask for a month, full cycle continuance if possible.
We do 2-month cycles typically over here, but what was the next VOP date after February 6th? March 27th?
Yeah, that works perfect.
All right, March 27th. All right.
The next case, Your Honor, would be Mr. Larry Leonard.
That was the one I was looking at
Yes,
when
sir.
you were talking, so I apologize for that. Is he present?
He is, yes,
Okay,
sir.
Mr. Leonard.
And so for Mr. Leonard today, the defense is going to be withdrawing both of the previously filed motions in this case.
Okay.
With the anticipation of refiling a constructive possession motion for count 2, which has been added to the information. The trafficking in fentanyl charge was added to the information after the original motion to dismiss for constructive possession was filed. So we need to go ahead and amend that and include the second charge. We're also withdrawing the immunity motion today.
Okay. Ms. Leone, any concerns with continuing it for that purpose?
Well, I think the case should be set for the next pre-trial, and
Yes,
then we take it from there.
Yes, February 24th, 9 o'clock.
Thank you so much.
Thank you.
Let's see if by that date, if we can get those motions filed and reset so we can
course.
move along with it.
It's good to see you, Judge.
Oh, with the amended information, was there a direct file KPS?
He hasn't been, and there is a KPS, I'm requesting the KPS, right? Yeah, of course. Yeah, it's still, yeah.
I didn't know that, Judge. Didn't know it hadn't been addressed yet.
Y'all want to potentially address a bond situation for him?
No, Judge, I don't.
So first, he'll handle his first
Yeah,
appearance
it's going to be
tomorrow.
probably set on a PTD date because of the charge.
Well, we have
The
those.
incident resulted in the death of a person by fentanyl, so it's.
Oh, is that what the new charge is?
He's not charged with.
He's not charged
you know,
with,
he's
I mean,
not
I read
charged.
your motions
Yeah,
yesterday.
he's not charged
So I know
with
this-
anything regarding the death. He's charged with trafficking and fentanyl, Judge.
I understand.
Yeah.
But that's still a pretrial detention here.
Yes, sir. Thank you, Judge.
All right, thank you, Mr. Sutherland. All right, Mr. Nopes.
I've got Christopher McCoy on a motion to modify the conditions of bond. He's present.
This is 24 CF 2540.
Yes, sir. Judge, Mr. McCoy is in the Air Force, 15 years in. Part of what his job is that he needs to be able to possess a firearm. He is also scheduled, they're going to, I guess, deploy him or send him out of the country on February 15th. And where he's going is going to be a combat zone type situation. And so he needs to be able to possess a firearm for his job.
State's position?
Your Honor, the state will leave it up to the court to make that decision.
Sounds kind of like something we deal with in domestic violence injunction court pretty frequently, which even though you're not allowed to possess a firearm, I can allow you to do so for purposes of job-related, if it's law enforcement or military. So if you'll get me in order, Mr. Nopes, I'll grant your motion allowing him to use or possess a firearm so long as it's regarding his actual duty and only inside of a military installation or during his particular deployment. They're going to deploy you while you've got a pending felony charge?
Works.
Okay.
Judge, in this case, the allegations are not that he brandished the weapon.
Oh, I know. I read it.
Okay, I just didn't know if...
Mr. Nopes, you know I read everything.
It's a very,
He's accused of shooting at a drone
the drone, yes,
that was surveying the neighbor's
was
land.
on top of his house.
I'm not
that's
saying
my
you did it, sir.
understanding.
I'm saying that's what the allegation is.
Right.
So I understand what the situation is. I've read it. I don't have a concern with him possessing it for purposes of his job, but only that. And that, again, that means only on the military installation. There's no reason for you to bring it outside of the gate.
Okay, I'll
So
send you
give me
an
an order and make sure that's in Word, Mr. Nope, so I can edit it if I feel the need to. Send me an order, but send it in Word so that if I need to edit the language, I can do so.
Absolutely.
All right, thank you, Mr.
I
Nopes.
thought all orders had to be in Word.
Not everyone follows orders.
Only reason
I
know that-
didn't accuse you of that, Mr. Nopes. I just like to say those things so it's on an extra phone call or email on behalf of my office to make sure those things happen.
Ever tried to submit,
Okay.
but it seems like that system wouldn't take it because it's a requirement, I think. But anyway,
It is what it
I'll
is.
absolutely send it.
Thank you, Mr. Nopes. Thank you, sir. All right, Ms. Merrifield.
I think we're ready now, Judge.
Okay.
Brandy Merrifield on behalf of Gregory Austin. It's 23 CF 895. And Judge, we're here today on Mr. Austin's motion to reinstate bond. I know the court has had the benefit of the motion, so I'm not going to go through the specifics that were found in the motion, but there are some important factors. So Mr. Austin was released on bond April the 19th, 2023. He had 5 separate offenses, all related to 2 minors. So it was multiple offenses with 2 listed victims. In December of 2023, there was an affidavit by pretrial services that said essentially claiming that he has violated the conditions, the special conditions of bond, and there were 2 references. One referenced being found on an internet device, and then another one referenced possessing or carrying a firearm, which were conditions of his bond. I'm going to direct the court to, I have dockets number 82, 87, and 88. Those are the references that I'm going to be referring to today. So Officer Croft with Pretrial Services alleges those conditions based on affidavits that were...
Let me try. 82 is not coming up for me. I clicked on it. It says it's got 0. Let me check in the clerk's website. Maybe that will help me out. But
And your docket may be a little different than mine.
That's the document I want to see
Okay.
is number 82, but it won't pull up. So go, but keep going and I'll look that up.
Thank you, Judge. So in Officer Croft's affidavit, she is stating that there were affidavits received by Crestview Police Department on December the 14th, 2023, making these allegations, carrying firearms, being connected to the internet. But Officer Croft's affidavit, and that's specifically the document that I would like the court to look at.
See it now in benchmark.
Thank you, Judge. The attachment that was attached to Officer Croft's affidavit is barely legible. It looks like an extremely blown-up, handwritten document, which doesn't provide a whole lot of information. That document purports to be December the 29th, 2023, which is after the affidavit is dated for Officer Croft.
Where is the affidavit attached?
So I attached it to the motion, Judge. I can just show
here it
you a
is.
picture of it.
I've got it now.
Okay.
Where's cut off?
It is. Essentially, this is what is found attached. So in the court docket, we have the affidavit by pretrial services as an independent document, and then we have another affidavit attached to the actual warrant that shows that cut off, really blown-up document. That document, the blown-up document that's attached to the affidavit, is a date after Officer Croft's affidavit. The statements from the Crestview Police Department were not attached to that affidavit indicating that he violated. What I found to be interesting is, even though the information is cut off and not very legible, there's no information in that affidavit that's attached that discusses a firearm, and the part that talks about access to the internet states that it was a cell phone, but it did not have Wi-Fi capability. You can see that towards the bottom of the document. There's no name associated with it, no evidence of notarization. I'm not sure where this affidavit came from. The affidavits that I believe were associated or that should have been attached and were not attached, we did receive those on January the 28th of this year. It was 3 different affidavits. It was by, I'm sorry, sir?
Of this year.
Yes, and it was the 8th amended discovery that we received it. Those affidavits do make those allegations that Officer Croft references in her affidavit from December. When I looked through those affidavits, Judge, it discusses being on a phone watching football, it discusses being on a computer paying bills, and it discusses looking at Nest cameras. What I found to be interesting is that all of those items that are alleged can be done in offline services. Mr. Austin's allowed to be on a computer. He just can't be on a computer that's connected to the internet. So there is no information or no evidence to show that he was physically connected to the internet other than what these affidavits are alleging. Same thing with watching football. It can be downloaded.
How do you pay bills without being access to the internet?
So his brother was in custody of paying all of his bills. I have no knowledge that he was on the internet. I don't know if he was looking at old bills, or Mr. Austin's contention is that he was not paying bills because he had no access. That's why he gave it to a trusted family member to do so.
Was the football watching on a computer or was it on a phone?
So according to the affidavits,
I can see that they were turned over 2 days ago, but I don't have access to the actual affidavit. Is that okay, Ms. Merrifield?
yeah, absolutely.
Thank you, Ms. Boston.
I may approach, these are the copies.
That's the same thing.
I just want to be able to read them so I know what the exact allegation is. Thank you.
And I'll give the court an opportunity to look at those really quick.
Go ahead, Ms. Merrifield. I've read the affidavit.
Thank you, Judge. And as you can see by looking at those affidavits, I do want to draw the court's attention to the address that's listed on those affidavits. That's one of the very few things that you can see on the handwritten notation attached to Officer Croft. So this does come from the same location there in that Baker address. In the affidavits, it discusses that he would go to his room where the computer was, close the door, and say he's paying bills. That doesn't evidence that he's on. He can say, I'm paying bills. That doesn't evidence that he's on the computer. And the other information that was provided doesn't provide any information or any evidence that he was physically on the internet. He did have phones that were capable of no internet service as he was instructed by pretrial, and that is what the written statement says that's attached to Officer Croft's affidavit. So if the court is looking at whether or not to revoke somebody's bond based on an affidavit from pretrial, it certainly would have changed the dynamic if these affidavits that we just recently received were attached to the original affidavit
Ms.
from
Merrifield, the
pretrial.
situation is, the court did revoke his bond a year ago, and this
They
is a
did.
motion to reinstate, but now we're kind of attacking the reasons why something was done a year ago?
Yes, Judge.
All right, go ahead.
And my motion is on two different points. It is on the order revoking bond. At that point in the case, we did not move to reinstate because we did have several rounds of depositions. The court can see the nature of the charges. They're very serious, and the court is very aware how long that takes. There were several motions that ASA Barrickman and I had, for specific discovery, statement of particulars, and all of that information, I believed, would lead the case to a quicker resolution. Unbeknownst to ASA Barrickman and myself, gathering that information took a considerable amount of time, several months. We have had 6 rounds of depositions, many witnesses unable to be found, some witnesses that were served didn't show for the depositions, and that's not an affront to the state because they've certainly made every effort to get those addresses. So now we are bringing it back to ask the court to reinstate the bond based on the length of time that this has taken, and based on the affidavit by pretrial.
State's position.
Ms. Merrifield has already stated, and the court is aware, Mr. Austin is charged with some very serious sexual offenses alleged to have occurred over time. Based on the information provided to the court did put some safeguards in place that the court felt would protect the community and children from Mr. Austin while he was out on bond. But Mr. Austin has chose to violate those conditions. If it's clear that Mr. Austin was actually accessing the internet, it does indicate that the iPhone that is a device TikTok, the paying goes online, or that is how it is done. He indicated to the witnesses that he was actually paying, also looking at it. So the conditions that were put in place by the court were important to the court. So we are asking the court. You know, as far as the deposition, I believe Ms. working to get them as quickly as possible. Addresses and get the witnesses available.
What type of witnesses are we talking about that haven't shown up for depositions?
DCF, Judge.
Has there been an order to show cause against the people who
That would
weren't?
be my suggestion, Your Honor. I was speaking with Ms. Merrickman about it, and I know a lot of times Ms. Merrifield doesn't wish to push it that far because they are trying to get folks here. But
I would like to be heard
I
on
would
that.
believe
You'll get your chance. Let her finish, and then you'll
Yes,
get
sir.
your chance, Ms. Merrifield.
that may be an appropriate remedy, Your Honor, if all parties have already tried to do the respective best to get the individuals there. That may be the remedy.
Okay, Ms. Merrifield.
So based on current case law, Judge, the witness has to not appear for a certain specified period of times, and that's where we are. So we have had 3 DCF witnesses in particular that we've either had subpoenas refused, the agency wouldn't accept it, couldn't find them, even though that was the verified address that was provided to the state. And ASA Barrickman and I have been working very diligently trying to get those good addresses. Of some of the witnesses that we were able to serve, they did not show. But they have to not show for another served deposition before I can bring it before the court. So that is what ASA Barrickman and I have been discussing, is how we can facilitate that to move those depositions quicker. And to be fair, part of the delay in some of the depots, Judge, is there is an extensive DCF history involved with the listed victims, extensive, with allegations similar in nature to what Mr. Austin is charged with. It took ASA Barrickman the better part of 2.5 months just to acquire those documents and then have to make the proper redactments so that we were able to see that information. So it wasn't until we received that both ASA Barrickman and I were aware of these other witnesses that would be material to the case.
DCF's involvement is they've investigated other allegations made by the same alleged victim in this case?
Exactly, Judge, of a very similar nature. So the court found it necessary that we obtain those records.
What county is that in?
It's here locally, Judge. There are 2 different counties, but both in the First Circuit.
Well, I understand, but what are the allegations that are being looked into? Are those from Okaloosa as well, or?
Santa Rosa and Okaloosa.
Because the name sounds familiar.
Yes, sir.
And I can't place it without looking back into it, but.
There was a prior case, Your Honor.
I'm familiar with that as well.
Yes, sir.
What I'm saying is there are some names that were floated around as I read through this file yesterday that seem familiar to me, and they may have been part of a Santa Rosa case that I dealt with. That's about the extent I can go through. You know, I like to be as transparent as possible as far as what other cases I may have handled that I may have learned information. Obviously, Ms. Merrifield, you're aware that I handled the injunction cases that were filed.
Yes, sir.
Because you were present for those. I'm not sure where that name comes from, other than it just seems familiar to me. But,
understand, Judge.
So that's, again, just trying to be transparent. Here's what I'm inclined to do at this point. I'm going to deny the motion. However, these depositions are set, and these people are served, and they failed to show. You are free to put out an order to show cause on my very next court date, and we'll address it at that point. These are people who were not just state witnesses, but people who are employed by the state. They should be showing up for subpoenas. That maybe there's some issue why they haven't, but that needs to be explored. I know that's not your case, Ms. Basso, but I'm sure Ms. Barrickman's taken diligent efforts. But you know, we can't just keep pushing these cases off because people don't show up for depositions. And frankly, I think more motions should be filed by both sides to get things through the system quicker, whether that's motions to compel, orders to show cause. I think it just makes for quicker and more efficient resolution of cases.
Absolutely, Judge. And we have certainly enjoyed the motion practice in this case to try to advance it. But we will do that. We have depositions scheduled in February, and if we have no shows, then we will bring it before this court.
And just to make sure, I've now looked at the reports or the affidavits. It seems pretty clear to me that there was some usage. And to say otherwise would be that he was watching something that was loaded into an iPhone probably months earlier. I don't find that, I mean, not that he's testified to that, but it just doesn't seem credible at that point. So, but I'm going to deny the motion without prejudice, bring it back if this continues to get delayed through no fault of the defendants, and then I'll certainly readdress it as quickly as possible.
Thank you, Judge.
All right, thank you. Okay.
Yeah.
Can I give that back to you, Ms. Basso? Thank you. All right. Ms. Merrifield, did you have anything else?
I don't, Judge. That's all I have to
Okay.
say. Thank you.
Ms. Flowers, are you ready with your cases? All right, go ahead.
First, before, I can call Mr., this is actually not on our docket. A motion for bond modification was filed, but it was filed under Judge Gontaric's so I don't know if you have access to it, Judge, but he is here. The state has stipulated, this is just I'm asking, the defense is asking the court to
What's his
modify.
name in case?
Oh, it's James Llewellyn, and it's 24 CF 2311.
All right, who would have this case for the state?
It's me, Your Honor.
Any issues with going forward with the motion today?
No.
Okay.
We've discussed it already. Thank you for checking.
I always ask, yes.
Yes, sir. Thank you.
In front of Judge Carrick still, but I haven't seen the motion. I can read it right now, but go ahead, Ms. Flowers.
It's fairly simple. The state has generously stipulated to agreeing to remove his ankle monitor for purposes of him obtaining an MRI that is needed. He is disabled and has a lot of back problems. We're asking the court, though, to consider just removing it, not just for the MRI, just indefinitely. He has fallen a couple of times. He does use a cane, and he has fallen and hurt himself several times. He has trouble getting dressed with the monitor. He has multiple medical appointments that he has told me about, and is really struggling to really walk and function with the monitor. And so that's what we're asking the court to consider. I don't know, I actually didn't discuss that with the state, so I don't know if they would object to that, but he can elaborate more on his medical condition.
Give me 1 second. What's the state's position on the more lengthy removal of the GPS monitor?
I object. I wasn't prepared to argue that. I would have to notify the victim. Victim intends on going forward. My agreement was to have the GPS removed for the purposes of the procedure and then reapplied.
What else would you like to tell me?
Is there any other information? If the court, could we reset the hearing as to the 6th for the state to have time to contact the victim?
No, Your Honor, because my argument would be that there is no change in circumstances, so there is no reason for the motion. After we were allowing him to get it removed for the procedure.
I'm fine to remove it for the procedure, then have it placed back on, but any further motion will have to be reset at that point.
Month I'm trying to get so going to have another set of injections with RFA. I don't
What is an
plan on,
RFA?
radio frequency ablation with a blind. It's my 4th go around.
Get me something from a doctor's office and I'll certainly consider it.
It's a procedure that they do, like a small surgery.
That you need it.
Yes.
That's what I'm gonna need.
Yeah, you can get me
Evidence that you actually need that and it's going to be done, and then I'll reconsider it. Otherwise, removal for purposes of the MRI, I'm fine with that. If anything is needed further, then you're gonna have to show me some documentation.
Thank you, Judge, and we have a meeting set for next week that he can provide that documentation. You'll have to schedule your appointment and get us the information of when the appointment is.
Okay.
And then we can do an order at that time.
Thank you.
Thank you.
Honor charged there with state probation. Is he on pretrial or is he on probation?
He's on pretrial.
I was going to say, because we can take care of that ourselves. We wouldn't have to come to court for that. But I
Yeah,
understand.
pretrial supervision.
Pretrial's different.
That's order of court, so,
All right, thank you, Mr. Llewellyn.
okay.
What do you have
That's fine.
next?
I have,
Am I done?
yes, you're done. Let's see, I've got, I wanted to address this afternoon's docket briefly, or I can stay with the morning if that's, I'll stay with the morning. Okay, Justin Cox, he's in custody. And Your Honor, this was set for an evidentiary hearing, but we've stipulated to continue the evidentiary hearing on the VOP due to, I was just recently appointed on the case, and so we're asking to continue to the 6th.
The 6th of next week.
Yes.
There's no objection.
Mr. Cox, any concerns with that?
No, sir.
When did you just got on the case within the past week or two, right, Ms. Flowers?
Correct, and and actually just today, we might have a negotiated plea on that date as well.
All right, so let's put it on February 6th.
I was just going to say, if we're going to do subpoenas for a hearing, I don't think, I would not be able to agree to the 6th just for timing purposes, to reissue them.
Do y'all want to talk more about, see if you have an agreement today?
We talked a little bit before court, and my office is needing to hear back from the victim in the underlying violation case, Judge, and we might be able to work to something, but nothing that I can commit to. Could we leave them on for the 6th without sending subpoenas in the event we can work it out, and then set it for a hearing if we have to have the hearing?
Yes, that would be.
Cox, any concerns with that? All right, February 6th, do you want 9 o'clock?
Thank you.
All right, thank you, Mr. Cox.
Above that is Ricardo Bryan is on the docket, 18 CF 1425. A notice of cancellation was supposed to be filed. He is in another in another institution, and I still need to meet with him. So.
You were just assigned this case like
Yes,
a week ago.
correct.
What date would you like to put it on? He's in DOC, right?
He's in another, I believe so. I think we'll probably need a little more time than that to get a motion to transport filed.
What ultimately are we going to be here for?
It's like a new case, Your Honor, basically. And I would suggest, can we set it for the next pre-trial, and then
That's fine.
we see where we are?
Yes, February 24th.
February 24th. We can cancel the 2-6.
I'm not sure you have discovery, right?
No, I don't have anything yet, yeah.
Basically, what it was, there was a motion for new trial that was denied. That's since been vacated.
Yeah, yes.
But, correct me if I'm wrong, wasn't it to come back for a new hearing on the motion for new trial?
I understood that it comes back for prosecution like nothing ever happened.
Because I think the situation was, it came back saying that the court had not inquired as to whether or not Mr. Bryan wanted counsel appointed before the motion for new trial was made and denied, despite the fact the court then asked him if he wanted counsel about 2 minutes after that when they talked about other issues. But that's what it came back on. So I think it's just about the motion for new trial, not that there is going to be a new trial. But I'll let y'all take a look at that.
We will.
Okay.
Yes,
Thank
Your
you.
Honor.
February 24th. I'm just trying to catch up on these things, but that's what I thought it looked like. All right.
Thank you.
You
Anthony,
want him transported for that? Let's do this.
we're
If
gonna
you have a
we're
chance
gonna
to
talk
speak
about
with
it.
him in the meantime,
Yeah.
you want him transported, file the motion.
Yeah.
All right.
And I guess if we need to continue it from the 24th, then we can also do that if we need more time.
Okay. All right. Thank you.
Thank you.
Next
Anthony
case.
Weeks.
Anthony Weeks.
Yes, this is Anthony Weeks here for, it's on the docket again for a VOP evidentiary hearing, but we are asking to set it for a date certain for an evidentiary hearing. The state and I have discussed, there was some new information that came to light that needs to be explored prior to an evidentiary hearing. I've discussed that with my client and the state, and there's no objection that I.
There's no objection. We'd like to go ahead and put it eventually those, so that way we can get it resolved either with a resolution of the plea or go forth to the evidentiary on that. That way, Mr. Weeks can have.
What date are y'all looking for?
What is available, Madam Clerk?
I think after the 6th, it's not till late March. How long do you think the hearing might take?
It may just be a plea, Your Honor.
Okay, so let's put it March 6th at 2:30. Well, let's say 2 o'clock, because the arraignment date doesn't usually take that long.
That sounds good, Judge. And if we do get a resolution prior to that, if by the 6th, let's say, for instance, in February, we can just pop it up.
Thank you.
All right, sounds good. All
Thank
right.
you. Thank you,
Otherwise,
sir.
March 6th. Thank you, sir.
Your Honor, Samuel Mosley is also showing on the docket under Rudy Harper's name. It's my understanding that Mr. Harper also filed a notice of cancellation based on him not being transported from DOC.
Turns out he's here.
Oh.
He showed up like yesterday, I think that happened, but, Your Honor, Mr. Harper also had indicated that he had tried to get some witnesses. Originally even gonna ask for continuance based on that. Based on the fact that Mr. Mosley is incarcerated, the state didn't have an objection. I believe we may have a new date already. No. Harper was trying to coordinate one yesterday, and I believe we had come up with one that offered us, but I don't know that he followed.
I don't see a new date, but then again, my system doesn't update very quickly sometimes.
Probably,
Let's say March 27th at 2 o'clock. If he decides something works better, then just file a notice for that, but I need to give it a court date.
Thank you, Your Honor. That works for the state. We've confirmed it with our witnesses already.
Okay, perfect. Where was he in a DOC? Flowers, I know it's not your case, but it's your agency's case. Do you want him sent back, or do you want him to remain here?
we would request that he remain here until
I'm going to need an order, otherwise it's probably going to happen.
Yes, Your Honor, so you
if
would.
you could have your office send over an order.
Absolutely.
Instant, right away.
We'll do that right away.
So that we can, otherwise he's going to get transported, especially if he's local, but.
I'll make contact as soon as I get out of the courtroom, and we'll have an order sent over.
All right, thank you. Anything else?
Yes, Your Honor, I wanted to address this afternoon's docket, if that's all right. Catherine Lockhart, in case number 21 CF 1577 and 18 CF 751, was set for an evidentiary hearing on a VOP as well. And I was just recently appointed, I think within the last few days, and have not had a chance to meet with her. I discussed with the state a continuance, and I don't believe there's an objection.
That's correct, no objection.
I guess my only concern is that Ms. Lockhart doesn't know that.
Is she,
Y'all were just appointed 2 weeks ago.
I was not aware that it had been that long, but.
January 15th. We put on February 6th without subpoenas, just to see if y'all can talk to her in the meantime, see kind of where we're at. I just don't like the idea of her getting pushed off for a month, not knowing
Yes.
what's going on with her case.
Yes.
All right, so we'll put that on January 6th without, February 6th without subpoenas.
Yes, sir.
And I guess Joseph Sawzak is not here. I had filed a notice of hearing, and I guess it didn't get set. He's not here. Oh, okay. All right, Your Honor, I'll file another notice of hearing to get him in on the 6th as well. And I believe that's all I have today.
All right, thank you.
Thank you.
That's what I was just looking for, because I saw him when I was. Here it is. All right, let me go ahead and get some people who are not represented. Nolan Cheshire. Y'all have him, Mr. Russell?
No, sir, not yet.
I'm looking at, there's one case that's listed under Mr. Gibbs for the 1:30 plea, for the plea date this afternoon.
I thought there was.
Was that a different one? Oh, my mistake. Cheshire, you're here in 23 CF 54 as well as 22 CF 1321. You're currently self-represented. Do you want me to talk to you about appointing a lawyer for you?
I got a letter while I was locked up.
I'm sorry, what?
Got a letter from the public defender's office while I was locked up, saying I was appointed one.
What it is, Judge, Mr. Cheshire also has a misdemeanor CT case, 25 CT 41. We are on that case.
Okay, so would you like me to appoint the public defender to you on these cases as well? Okay. Public defender will be appointed in both of Mr. Cheshire's cases.
Judge, what I would propose to do, since the basis for the violation of probation in these cases is based on that CT case, the CT case is set for February 4th for an arraignment, so I'd like to pass the VOPs to February 6th. At this time, we'll deny the VOPs and set it for February 6th, see what happens on the CT case, and then we may be able to take care of these on the 6th.
What day did you say the CT case was?
2-4.
2-4, all right. So we'll put you down for February 6th, so you can go to misdemeanor court or criminal traffic court on the 4th, and you'll come back and see us on the 6th, Mr. Chesser.
Thank you.
Thank you. All right, William Frazier. All right, Mr. Frazier, you're here in 21 CF 2920. Appears to be a violation of probation. Do you understand that?
Yes, sir.
All right. Do you want me to talk to you about appointing you a lawyer?
Yes, sir.
Are you currently employed?
Yes, sir.
About how much do you make a month?
About $1,500.
I'm going to go ahead and, say, provisionally appoint the public defender's office. You're going to have to fill out one of those applications. There may be one on the podium there.
No, I'll give him one, Judge.
Okay. And just fill that out and turn it into the clerk's office on the first floor before you leave here today.
Yes, sir.
This appears to be a VOP based solely on monetary issues.
Correct, Your Honor. I used to supervise Mr. Frazier. He now lives in Walton County, but I know him.
Okay.
It was just a case of restitution. He has been paying on his restitution. He just is not going to be able to get it paid. His termination date came. The department's just recommending that the restitution go to a civil judgment and he terminate.
Russell, do you want to?
Do I have just a second, Judge?
Go ahead.
Just a backstory on him. When I first got him, he was homeless, young kid. Worked hard with him to get him up to speed. He has been working at Burger King, to my knowledge, and has not committed any new law violations, reported on time and all that. It's just a matter of the money.
Judge, I talked to Mr. Frazier. If that's what probation is asking for and the state's willing to do that, then we'd be asked to be relieved so that we didn't have to pay the money for that, but then go ahead and terminate and then enter the judgment for the rest of the money.
Would that be a admission to the violation with a termination and civil judgment?
Judge. And in situations like this, when there is a victim in the underlying case, our office is obligated to reach out to the victim for input and also whether or not they would like to be heard at any sentencing, which is their right if they elect to. I don't have a response from the particular victim in this case, but that would be a reason why I'm not prepared to do that today.
Judge, what I might suggest then is still relieve us, pass it for the state to talk to the victim.
Okay. How long do you think that'll take, Ms. Turner?
May I just have a brief moment, Judge? I'm
Sure.
going to review my file.
Okay. Unappoint or relieve the public defender, so he doesn't get charged for that.
Yes, sir. It looks like based on the note in the file, our office was able to speak to the victim, I believe Mr. Deason, and he is in agreement with the probation's recommendation. So we actually have that answer already. We can do that today, Judge.
I just know someone with that last name. I want to make sure it wasn't someone who's a friend of mine with that same last name. It is not. I've looked that up to make sure. All right. So what the state's offering is admit, terminate probation, civil judgment as to the balance of the restitution, which I think was, at least as of the affidavit, $843.19. Is that what you want to do? Okay. Raise your right hand. You swear or affirm the testimony about to give us the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. State your name, please.
William Frazier.
All right. You can put your hand down, Mr. Frazier. You understand what they're asking you to do is to admit that you violated your probation by not paying this money. Your probation would be terminated today, but there'll be a civil judgment for you for that amount of restitution you haven't yet paid.
Yes, sir.
Is that what you want to do today?
Yes, sir.
All right. Are you under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Do you have any mental health concerns or diagnosis?
No, sir.
All right. Do you want to talk to a lawyer before you enter this plea?
No.
Plugging in. He still has a withhold. He has a withhold right now. I don't know if I want to adjudicate him if it's going to make him a convicted felon over an inability to pay restitution. I'd terminate his probation to make it a civil lien anyway, without him pleading to. I just don't want to. Typically, when you have a violation of probation and you have a withhold of adjudication and you admit you violated it and we terminate it, you get adjudicated. I don't want to do that because it makes you a convicted felon over simply not being able to pay some money that you're going to pay eventually through the civil judgment.
Judge, there'd be no objection to dismissing the VOP and sending to.
Okay. All right, so what's going to happen is that there's going to be a civil judgment for the $843.19, but the state's going to dismiss the violation of probation. I can't say whether I agree or disagree with things, but I think that's a good resolution to the case.
Sure.
All right, so make sure, does he need to talk to you on the way out?
No, Your Honor, we just asked the all Department of Corrections.
Okay, if there are any outstanding DOC fees or costs, those will be waived. We just want to make sure you pay that restitution.
Yes, sir.
So I can't give you any legal advice about what a civil judgment means, but basically it's going to come up on your credit report and things like that. So it would be in your best interest to pay that off.
Yes, sir.
Okay. And there was no concern with that from the victim, as far as you know?
That's correct.
I mean, civil judgment's the same thing it was going to be as this.
We had advised the victim that was what the state attorney's office was inclined to do, where they would no longer have an opportunity to get that payment.
Okay.
Unless they pursued the order on the judgment.
Okay.
And my understanding from the victim and his wife is that they're fine with that offer. They did not want to give input at the resentencing.
Okay. All right, so you're off probation. It's been terminated, but just make sure you keep paying on that judgment.
Yes, sir.
All right, thank you, Mr. Frazier. All right, Randall Hartley. All right, good morning, Mr. Hartley. You're here in 23 CF 2692 and 24 CF 48 for a violation of probation. Do you understand that?
Yes, sir.
Oh, okay. Hold on just a second. Mr. Hartley, you also have 24 CF 2882. That's on our afternoon docket, but since you're here, we'll handle all of those things together at this point. And that's a new charge of battery on a law enforcement officer and resisting without violence. Do you understand those charges? Okay. You want me to talk to you about appointing you a lawyer for these cases?
Yes, sir. Is battery upon a Leo the same as obstruction against an officer?
There's all sorts of different charges. There's resisting without violence, there's resisting with violence, and then there's battery on a law enforcement officer. And essentially you get charged with all the three depending on what the facts are.
Yes, sir.
But I don't know anything about the facts of your case at this point.
I would like to be appointed attorney or lawyer before I speak.
All right, I'm going to go ahead and appoint you the public defender. You're going to have to fill out one of the indigency forms at some point and turn it in. Mr. Williams is here from the public defender's office. This is Mr. Hartley. He's got the new charges as well as 2 VOPs.
Judge, I'm going to enter a denial for him on the VOPs, and if we can go ahead and arraign him on the new charges. Madam Clerk, has an information been filed? Oh, okay.
They gave him one this morning.
All right, Judge, in that case, I'll enter a plea of not guilty, request 15 days for any pre-arraignment motions, and demand trial by jury.
It looks like he's already set for the February 24th pretrial
All right,
date.
Judge.
So we'll put those all together for February 24th. But Mr. Hartley, just, because you're currently incarcerated, it might be the 26th when you actually have court, if you remain incarcerated at that point. All right, we'll see you back on those dates.
All right, sir.
All right, next unrepresented is John Horick. Mr. Horick, you're here in 23 CF 2162 for a violation of probation. Do you understand that?
Yes, sir.
Do you have anything else? Okay, just want to make sure. Do you want me to talk to you about appointing you a lawyer for your case?
Yes, sir.
All right, can you afford one?
No, sir.
Are you currently working?
No, sir.
Do you have a bond?
I don't think so. No, sir.
All right, I'm going to go ahead and appoint the public defender for Mr. Horick, who's here on a violation of probation.
There's my card. You're going to have to fill this application out. Go ahead and represent you for today's purposes. All right, Judge, I'm going to enter a denial on the violation of probation. I don't see where there's a new law violation set for this afternoon.
That was confirmed by Madam Clerk. All right, where would you like to put him?
Judge, I'll still need to meet with him and go over any potentials. I don't think we're going to necessarily be able to get this resolved by the 6th. Does the state already have an offer for him?
Yes, the state's offer is 1129 county jail, revoke and terminate probation, all court costs.
Unless you've got a lot of time built up already, that would not be getting you out of jail, so we might as well have me come out and talk with you.
Okay. I just did 6 months violation.
That would be a different case, though.
Okay.
All right, so what we have, March 6th? March 27th. Obviously, if y'all work something out, get it on an earlier docket, and we'll take care of it.
All right, thank you, Judge.
All right, thank you.
All
Thank
right.
you, Mr. Hort.
Take all this with you, fill that out, and submit it through the jail.
All right, Laura Rooks. All right, you Miss Rooks?
Hi.
All right, Ms. Brooks, you're here in 21 CF 159 and 21 CF 1405 for violations of probation. Do you understand that? Want me to discuss appointing a lawyer with you?
No.
What would you like to do then?
If I may, Your Honor, if I may mention the offer, she may affect the way she decides on the lawyer.
Okay.
The offer is for an admission to the violation of probation and modification of the current term to add 1 year for her to complete the original requirements.
I want to, so you're just saying to extend it by 1 year?
Yes? Yes.
Probation?
Honor, if I may, there's a few issues with the view.
Okay.
It should have been submitted for 20 CF 3226, 21 CF 159. However, 21 CF 1405 is on the VOP, so the wrong case was reopened. 1405 does not term until 2/25/28.
Okay.
Oh.
What was the other case number? Not the
The
15?
two that should have been opened were 20 CF 3226 and 21 CF 159. Those are scheduled to term on 2/25/25.
Okay.
And then another small issue, this is no fault of her own. In those two cases combined, she owes $8,500 in restitution, $665 in court costs for 23-226, and $615 for 2059. She has been making payments. She was originally sentenced to 48 months of probation. 23 months she was in Path of Grace, kept a job since being released from Path of Grace, making a minimum payment of at least $100 every month that she came. A month is only 25. The issue is that she's paid a total of $3,725 since she's been home. But because she has multiple victims and multiple cases, that money gets split between all of them. So it was split between all of her victims on all the cases. So it's kind of difficult to get the $8,500 paid off first because by law we have to give everyone some.
And it looked like the priority was the larger case, and that's where the majority of the money's been going.
It went to all of them. I looked it up. It all got split up.
The two cases that you're saying should be here, which is 3226 and the 159, were both dealing with stolen property, which are second-degree felonies, correct?
Yes, Your Honor.
So she was given 4 years of probation, but she's got the potential to get up to 15.
Yes, Your Honor.
So I'm not saying that in a way that I'm trying to make it sound like you're going to be on probation for the next 11 more years, but that they can give you more time in order to get things paid.
I mean, I'm willing to run whatever we have to do, you know what I mean? I'm just trying to get through this.
I understand. I'm just...
I still have 3 years with the other case.
I understand. No one's trying to say, head out the side door here because you haven't got things paid. What I'm just trying to make sure is how much time is left that we can possibly put you on probation and get this stuff paid off, because otherwise, I think this happened a couple of weeks ago. There was a request for an extension of 2 years when the person had already done 4 and the maximum was 5. So I'm no math wizard, but that's too many. So.
Well, I know on my larger case, which is the one I guess I was here for, which I'm not supposed to be here for, at the end it said that if it isn't paid, it goes to a civil, like they just did with the previous guy.
I understand.
Yes, so that's how we kind of.
But the difference is.
Because it's such a large, but this one doesn't say that.
Well, the difference is these are second-degree felonies where they have much more time.
Yeah, all of mine are large. I don't like it. I understand.
What they're asking to do is for you to admit that you haven't paid this, and that violates your probation, but they're going to just put you back on another term of probation.
I'm fine.
Extend it for a year, basically, so you can keep paying off these things.
So for just a year, though, because what I would like to do is do it for the 3 years that I'm already on probation for.
Your Honor, what I'd be asking is.
So you asked for 1 year of probation, and she
I know,
countered with
case,
3.
Right? I mean, I just don't want to have to come back in here and do this again because it's like nerve-wracking.
I understand. It's just a little bit of a rarity that someone's like, can I get some more probation than what you're asking for, State? Go ahead, Ms. Leona.
What I was saying, since the case has been, one of the cases, the 1405, has been opened by mistake. We are here only on the other two cases. What I would ask is to modify those two the probation, to extend it, to terminate along with the one that terminates in 2028.
Okay, do we have that date in 2028?
Yes, Your Honor, it is February 25th, 2028.
I guess, but technically the 3226 case is not on the docket and there hasn't been anything filed. Well, there is the letter that was filed by probation. Is that a Fort Walton case? Is that why?
No,
It says the correspondence went to Judge Clark, who,
I think it was the first person that we could get me in with, because as of February 25th, there was no, they were just trying to get me in with somebody.
I don't think so. I'm not trying to say you're deceiving me in some way, but I just don't know why it would have been, the letter would go to Judge Clark if it's.
Because I think they were looking at the wrong case, because mine is just complicated. I think that's what happened here.
I looked in CCNS, Your Honor. The 20 CF 3226 did not have a VOP.
I don't see, there's just the same correspondence letter that was filed from y'all to the court. But it has 3226 and 159 on it. It's just the letter that goes to the judge.
Amend the VOP to add CF 3226.
I'm just trying to catch what everything actually says, because the concern is the VOP is in 1405, which is the one where she's not even out of time yet. So the way I look at this, y'all are telling me 1405, she has much more probation left. Let's see. All right. So in 21 CF 1405, she got 60 months of probation. February 27th, 2023. So that puts her to basically February of 28. That's the only one I have a VOP in. So it looks like they violated you in the wrong case.
But that doesn't, that's.
We're going to get it figured
Certainly,
out.
that
The
doesn't-
problem is I don't want it to be as confusing as it is.
Because, I mean, we're here. We could just handle it all today,
Not
right?
necessarily.
We can continue
I mean,
and
we're
have the
here.
VOPs corrected.
There is. Is it 59? 55? Okay. So there was an affidavit. Was there an order, though? You have to go to court in Fort Walton back in December?
I did.
Okay, and did they tell you that you shouldn't be here?
No, they tried to give me 2 years extended, and I asked them for 3, and they said, well, we're going to have to review this and come back. And then we got snowed out.
Does she have another court date somewhere? I know this is taking longer than it normally would, but we just want to make sure it's right, because what I really want to make sure is that you don't have some court date in Fort Walton they expect you at, and then you miss that, and next thing you know, you're getting arrested for something we thought we figured out. January 21st date in the south end was never rescheduled because after the storm? Again, what I'm trying to avoid, Ms. Rooks, is for there to be some paperwork glitch where they think you're supposed to be in Fort Walton and someday they haven't told you about, and the next thing you know, you're being arrested because you didn't show up for a court date that you shouldn't have had.
No, that's how I found out about this one, is I looked online, because I never heard anything, so.
I think what happened was when they went to reschedule your January 21st date, they realized that you should be up here, not in Fort Walton, and put you on this date. But I just want to make sure it's 100% clear. So what we're talking about doing is having your probation modified in 21 CF 159 and 20 CF 3226 to extend it for a period of 3 years to basically run at the same time as your other case, which is the 1405 case. So round about February of 2028. Probation,
Yes, Your Honor, if we can just extend it until the term date of 2. There's one more. I'm sorry, this one's easy though. In 1405, 21 CF 1405, she actually has a special condition that she cannot be violated for unable to pay restitution as long as she makes a good faith effort. And that's the one that was incorrectly placed on the VOP. So we would just ask that stay and.
I'm not violating her on that case. All I'm saying is that we're modifying it. And the other two, 21 CF 159, 20 CF 3226, in order to give you 3 more years of probation to continue paying your restitution.
Okay, but one
Is that
more
what
thing.
you want to do today?
Yes, but one more thing. Sorry. Okay, so as you heard her say, in Fort Walton, I asked that my community service hours I did at Path of Grace, which I think I did like 3,600 hours. I was there for 23 months. Can we apply those hours to my court costs and fees? I understand not restitution, that's not a thing, but they agreed to it in Fort Walton, but
Well,
that's
I don't
not
know
in
what
Fort
was said
Walton.
in Fort Walton, because I can see what the memo says, but I wasn't a part of it.
Well, that's why I'm asking you. I don't have the paper with me to show my community service hours, but I was there 23 months, and I have a lot of hours built up. I'm just asking if we can apply those hours, if I bring the proof.
I think this is what we need to do. We need to have some sort of document drafted up in order to have all this right. Because I think if I just put it in, we just put it in the clerk's minutes, it's still going to be shaky at best. Because I think we need an actual agreement modifying it to these dates. So, and I point the public defender to do that with her and waive that cost. Mr. Russell, do you have an opinion on that part?
So I represented Ms. Rooks on the cases that were up here. I don't remember if it was all 3 or.
No, it was just the second one, the
Okay.
one that,
I don't know that if you can waive the fee, Judge. That's my answer to that. I just don't know the answer to that.
We're not here to talk about community service issues today. It's about the violation. So, I mean, I'll certainly let probation take a look at that then. And then if there's any issues, y'all can bring it back. All right, thank you, Mr. Russell. All right, ma'am, is that what you want to do? Do you want to enter an agreement
Yes.
to modify your probation for it to be 3 more years, which will take you to about January of 2028, January 30th of 2028?
yeah.
Yes, so you know you'll be back on probation for that amount of time for 3 more years?
Yeah.
Yes?
Yes.
Okay. Anything else that we need to change?
No, Your Honor, I wanted to just mention to the court that I did find some notes from the prosecutor from Fort Walton Beach and what they were talking about. Realistically, I think the cases should go to Fort Walton Beach, and
Why should they go to Fort Walton Beach?
because the lower case number, it's a Fort Walton Beach case, so that's a rule that we use, and all the cases follow that.
But we're here.
I understand. So it's up to the court, whatever court decides.
All right, Ms. Rooks, raise your right hand. Do you swear or affirm that the testimony you want to give is the truth, the whole truth, nothing but the truth?
Yes.
All right. Do you want to enter into an agreement to modify your probation for it to be 3 extra years starting today in the 159 and the 3226 case? Okay. And do you understand that by not paying that you haven't been keeping with the rules of your probation? Are you admitting that?
Yes.
Okay. All right. So what I'm going to do is enter an order modifying your probation in 21 CF 159 and 20 CF 3226 to extend your probation for a period of 3 years in each of those cases so you can continue to pay your probation. If you've got a concern after talking with probation about your community service counting towards court costs, talk to the clerk as well. If there's any confusion, bring it back in front of the court, and I'll certainly readdress it. But I'm pretty sure once everyone gets their paperwork in line, it'll all work out for you.
Okay.
All right.
Thank you.
Anything else? Having heard nothing.
Your Honor, you could go ahead and order her that she may do community service work in lieu of court costs, and then we'll go ahead and adjust that ourselves.
Okay, she can do community service, including credit for community service already done as part of her case with
Thank you.
Path of Grace. And then they'll make those determinations, figure out the numbers, and if there's anything left over, you'll have to either do more community service or pay those things off.
I've got like 3,600 hours. It's going to be fine. Thank you, sir.
I hope so. You're welcome. All right.
It's got to be fine.
All right. Make sure you talk to probation before you walk out. All right. I think that's everyone who's not represented. All right. Where do y'all want to start?
We have some out of custody judges, if you want
All
to deal with them.
Go ahead and call who you want, Mr. Russell.
Can we call Nicholas Atkins? Judge, this is Nicholas Atkins. Case numbers are 23 CF 373, 23 CF 531, and 24 CF 1457. The cases were set for today for a status and to get a report from conditional release. Ms. Valencia with conditional release is here if you want to talk to her.
Come on up, ma'am.
Huh?
I said come on up. You can just go to that podium, just so everyone has their own microphone.
Good morning.
Your name for the record, please.
Gabrielle Balancier.
And what is the status of Mr. Atkins?
I'm speaking with him daily. He's taking medication and stabilizing. And as of February 5th, Wednesdays, we're going to start comp restoration.
Okay. How long do you, I know it's hard to judge, how long is that, do you think that will take?
It'll probably just gauge off his performance.
Okay. So when do we
And
want to put this, Mr. Russell?
Judge, what I was thinking is that we could put it out, say, 3 to 6 months for another status. I would point out to the court and to the state that according to Dr. Zeman's report, which indicated he was incompetent, it was Dr. Zeman's opinion that he is unlikely to attain competency in the foreseeable future. But we can try this and see what happens.
When was that report given?
The report was filed, I want to say September 24. September 3rd, 24.
And I may be able to give a better update sooner than the 3 to 6 months, just depending on when we meet. Mhm.
May 29th, we'll come back.
Okay, Mr. Judge.
Make sure you continue to meet with her, and you actually do the training, correct, ma'am?
Yes, sir.
Okay. Do you have her information? You know how to get in contact with her?
Yes, Mr. Judge Davis.
Oh, okay. So go ahead and make sure you stay in contact with her. We'll have you come back in about 4 months, see how things are going at that point, and then we'll assess it at that point.
I appreciate it. Thank
All
you,
right,
Judge.
thank you. Good to see you, Mr. Atkins.
That'll be 9 o'clock, Judge?
9 o'clock. All right, next.
That's all my out of custody.
Okay. Mr. Williams, do you have people out of custody?
I do, Judge. I've got Michael Gomillion. All right, Judge, I spoke with Mr. Gomillion and went over the offer with him. He's not interested in accepting that offer. This case is, I believe, on the jury trial docket, so we need to put him back on for 224. He was set today in case there was a plea.
It was a PTI offer?
That's what I had as possible plea to a PTI.
I had it as withheld costs.
It was an alternative at the bottom of the plea offer sheet was I would also do a PTI 12 months, but that would include substance abuse classes and any recommended treatment.
Actually, I do recall that, and I think I went over that. Judge, he has no recollection of that. It may be that I missed it. He does want to think about it. Do you want to give him, do you want to come back? We got another date
Why don't we just
next
put it
week.
on the 24th, and if he takes it at that point,
Okay,
otherwise we'll
Judge.
set up for trial like he talked about.
All right. Schedule another appointment.
Mr. Gibbs gonna be coming back
For
this
somebody.
time? Or who's gonna be handling my
I'm
case
hoping
at
so.
work?
Right now, I'm still handling it, so schedule it with me, and if Tim's back before then Tim will see you. Okay.
Thank you, Mr. Gomillion. We'll see you back
All
on
right, thank you,
February
sir.
24th. Well, in the afternoon, right? 1:30.
Yes, sir.
1:30? 1:30, sir. You still don't know the status of that?
Closer, but that's all I can say. Mr. Hendricks, Davius Hendricks, and Judge, we've got a negotiated plea in this case.
Do I?
Yeah. Give it back to you, I think. Your signature. Let me look. Nope, I stand corrected. I have it. All right, Judge, this has got my handwriting on it, so you're going to need me to explain it. It's going to be revoking term, 60 days county jail with credit for time served. It's misdemeanor, so it'll be misdemeanor cost of prosecution, misdemeanor PD fees. The defendant will turn himself in by midnight on February 15th to begin serving his sentence, or he'll appear in court on 2/24/130 for the court to handle his.
Okay. Oh, okay. I got
And
you.
it's turning himself by, maybe turning himself earlier than that.
I don't know if the jail's going to like that.
Actually, no, it was another issue I talked with Major McDaniels about, Judge. Or does the court want, do we have a court date around the 15th?
I don't think so, because I think those 2 weeks are my civil jury trial weeks.
Do you want to,
I'll give him the date. He's going to turn himself in on that date. Otherwise, he's going to come in and potentially be sentenced to to including the maximum for these charges. Do you understand that, Mr. Hendricks? All right, raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay. All right, your name, please.
Davius Hendricks.
All right, and Mr. Hendricks, you're here in 23 CF 1874. It's a violation of probation based on charges of resisting arrest without violence, a first-degree misdemeanor, and driving while license suspended, second offense, first-degree misdemeanor. That calls for you to do 60 days county jail with credit for time served. Turn yourself in on February 15th by midnight. Otherwise, you're going to be in court on February 24th. Is this the state's agreement?
It is.
Okay. All right. Mr. Hendricks, are you under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Or do you have any mental health issues or diagnosis? Do you have enough time to speak to Mr. Williams, your attorney?
Speak to him? Did I have no time? Yes, sir.
Do you have enough time?
Yes,
Do you
sir.
need more time?
No, sir.
Okay. Did he answer all of your questions?
Yes, sir.
Are you satisfied with his advice and representation?
Yes, sir.
Anyone force, pressure, or threaten you in any way to enter this plea?
No, sir.
Anyone promise you anything in return for your plea?
No, sir.
You understand there's not going to be a VOP evidentiary hearing where the state would have to prove that you violated your probation?
Yes, sir.
All right. And how old are you and how far did you go in school?
How far did I go to school? I got my GED when I was like 17.
And how old are you now?
I'm 24.
Did you go over this form? Did you understand it?
Yes, sir.
And that's your signature on the back side
Yes,
of it? All right. Did you have any questions about it? Do you understand that if you don't show up to start your jail sentence on February 15th, you're to be come back on February 24th, where I'll be sentencing you up to, including the maximum, which would be
There are 2 misdemeanors, Judge. so-
11/29, so 11 months, 29 days times 2, so just under 2 years.
Yes, sir.
So you've got a big benefit or reason to show up for the jail on the February 15th date, right?
Yes, sir.
Okay. So it'll be 60 days county jail. I'm sorry, what is your plea? Are you admitting your violation of probation?
Yes, sir.
All right. I'm going to accept your admission as freely, voluntarily, and only given. 60 days county jail. Turn yourself in by midnight on February 15th, 2025. Otherwise, you're to appear on February 24th at 1:30. If you don't show up for jail and you don't show up for court on the 24th, a warrant will be put out for your arrest, and you can probably expect that you'll be doing 2 years in jail, minus
sir.
whatever credit you have for time served. You understand that?
Yes, sir.
All right. All right, you'll be adjudicated guilty. Misdemeanor costs for a VOP are $150 total for costs. All right.
Be revoking term.
Be revoking term on the probation. All right. Thank you, Mr. Hendricks.
All right, good luck, sir.
Any of his outstanding monies go to collections?
Yes, sir.
I've instructed him on how to go to the clerk's office.
There will be fingerprinted 30 days to appeal a judgment and sentence of the court. Yes, to make sure that he's turned himself in. All right. Do y'all have anyone else out of custody? Mr. Williams, do you have anyone else out of
I
custody?
do. Jonathan Eiley.
Eiley?
Judge, this is going to be a plea to a lesser included offense. Driving while license, misdemeanor driving while license. Charged on, I think it's 2 through 4. Yeah, 2 through 4. So there won't be a score sheet on it. It's for 10 days county jail with credit for any time served.
So he's still pleading to 2 through 4?
Yes, sir.
Okay.
Yes, sir. He's still pleading 2 through 4. That's why it's got 2 through 4 as charged, and then misdemeanor deal. But I should have put count 1. The wrinkle in it is it'll be misdemeanor court costs, and I'm not sure what that is on a DWLS. Cost of prosecution and PD fees, and he can serve the jail on the weekend. I did discuss that with Major McDaniels. She says that that is something that they can do.
They have a particular day and time they should report?
I talked with him. He can report by 6 p.m. tomorrow.
So
They just want on the record that the date he needs to report and the time he needs.
my concern about time, you say by 6 o'clock. What time is their normal shift change? It's.
The shift change happens at.
I thought it was at 5. Is it, maybe it's changed.
No, they go on lockdown.
It's been a while
for
since
count.
I've gone in there.
They go on lockdown for count at like 5:30, Judge.
Okay. And that's what I'm
And
concerned
then they
about.
come off lockdown at 7.
That's what I'm thinking of. So what time, do they give you a time that it's best
No,
friend.
Judge, she didn't. In my discussions with him, he said he could report by 6 o'clock.
PM. So
Yes,
that
sir.
would be Friday at 6 PM to Sunday at 6 PM to get credit for 2 days.
Yes, sir.
Okay. All right, Mr. Ali, raise your right hand. Do you swear or affirm that the testimony about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, your name and date of birth, please.
Jonathan Eiley, 11/19/1987.
Okay, and you're here in 24 CF 934, charged with drive while license suspended, HTO, but that's going to be reduced to a misdemeanor. No registration, improper tag, and failure to have insurance. You understand all those charges?
Yes, sir.
And did you go over this plea and sentencing agreement with your lawyer?
Yes, sir.
Did you have enough time to speak with him?
Yes, sir.
Did he answer all of your questions? Are you satisfied with his advice and representation?
Yes, sir.
Are you under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Do you have any mental health issues or diagnosis?
Yes, sir.
Anyone promise you anything in return for your plea?
Yes, sir.
Anyone force, pressure, or threaten you in order to get you to take this plea?
No, sir.
You understand by entering a plea there won't be a trial of any kind, and you're giving up your trial rights, which are enumerated in this document?
Yes, sir.
All right. You understand that you'll be waiving any potential defenses that you may have?
Yes, sir.
Okay, and what is your plea?
No contest.
No contest.
I'm going to accept your no contest plea to the lesser included count 1, driving while license suspended misdemeanor first degree, punishable up to 1 year in county jail, and as charged to counts 2 through 4, which are each 60-day maximums as a second degree misdemeanor. I'm going to adjudicate you on all counts, 10 days county jail with credit for any time served. $300 for court costs. Does that include costs of prosecution and PD fees? 50 and 50. All right. So $300 court cost, which includes the cost of prosecution, then a $50 PD fee, $50 application PD fee. Serve your jail on weekends starting tomorrow, January 21st by 6 p.m. You need to be there at the Okaloosa County Jail. You'll serve those from 6 p.m. Fridays to 6 p.m. Sundays for credit of 2 days. You understand that?
Yes, sir.
If you don't appear for one of those, you'll come back in front of me where I can sentence you up into including the maximum for each of those charges. Do you understand that?
Yes, sir, I do.
So that's basically a year plus 60 plus 60, so about a year and a half.
I'll be there.
Okay, just make sure you are. All right. Jail is concurrent between each of the charges.
Judge, I've explained to him about going to the clerk's office and getting on the payment plan. You're giving him time to either pay or get on that plan.
All right, 90 days to pay or work out a payment plan through the clerk's office to pay off those court costs. Okay? All right. If there's nothing else, step over, be fingerprinted. You have 30 days to appeal the judgment and sentence of the court. Since these are all misdemeanors, we don't need a PSI, we don't need a score sheet. All right, next case.
Stephen, are you set up to, because everybody else I have is in jail.
As far as I know of, Your Honor, Miss Weathersby is still in the Walton County Jail, as far as I know. I haven't checked recently, but she had bonded out here and went to the Walton County Jail. But there is this gentleman in the back row, Your Honor, and he had indicated he had.
All right, if anybody has court who hasn't been called yet, let's find out who they are.
Miss Weathersby, we'd ask for a capias so that when she's released from Walton, she gets brought here, Judge.
She bonded out. They sent her to Walton, and we're going to ask to bring her.
Well, she does have a suspended sentence.
I'm not saying we shouldn't. It just seems like why
Chad James and
Get her
Robert
here in the first
Settles. Mr. Settles is mine.
Hold on, Miss Rivers, as far as Miss Weathersby, they're asking for a capias to get her back over here. All right, capias on Miss Weathersby so we can have her returned when she's done with her Walton County case, no bond.
I think it was Chad James?
James?
Robert Settles. And I know Mr. Settles is on the afternoon docket for arraignment.
Hold on just a second. You know, we can't handle every case all at once. Chad James? You're on the 1:30 docket. We'll take it today, but make sure you show up at the right times.
I'm sorry, I apologize.
Oh, I'm not worried about it. You sat here all morning and,
Yeah.
because we didn't know you were here.
Okay, so I have to come back at 1?
Nope, nope.
Okay.
I'm sorry, sir.
Williams,
What's
I
your
believe
name?
you represent Mr. Chad James. He's on the afternoon docket, 24 CF 2922. Looks like an information was filed. He's just been given a copy of its possession of cocaine, third-degree felony.
Yes, sir, he is our client. At this time, I'm going to enter a plea of not guilty on his behalf, request 15 days for any pre-arraignment motions, and demand trial by jury.
All right. I've got him set for April 28th is his next court date for pretrial conference.
All right, Judge.
Your Honor, may I speak?
Sure.
I work offshore, so I may have to check my schedule, or do I just get with him on that?
Talk to him about that.
Okay.
If you need
Yes,
to
sir.
continue something or change your court dates, you know, we'll address it, but we got to know exactly what it is first.
Yes, sir. Thank you.
Yeah, you need to call the number on this card and schedule an appointment. Talk
Yes,
with
sir.
me. You can do that by phone, okay?
April
Thank you, sir.
28th at 1:30.
Thank you, sir.
Thank you, Judge. I appreciate it.
Yeah, no problem. Yeah, my only comment, Mr. James, is you sat here all morning.
No, I understand.
And we didn't know you were here. Otherwise, we would have taken you, so. All right, and what was the other case? Suttles?
Is this yours?
Yes.
That's on the 1:30 docket?
Mr. Settles?
All right. Mr. Suttles, I'm being told there's no information filed.
I don't.
State?
Judge, for some reason, it's not on my docket. I have to look at it. I know there were two that were recently added.
It's
where
set for the afternoon. It's a arraignment case.
What was the arrest date? Because there were two where the 21st day after arrest was not until
Oh,
February.
January 17th.
I think this is one, and if you give me a minute, I can speak more intelligently to it, but I believe there were two that were placed really abrupt.
His cases or just in general cases?
What's the case number? And I'll look it up, Judge. I'd like
25 CF 151.
151.
Looks like he was just arrested less than 2 weeks ago.
Yes, sir. I had not done the information because I haven't, the 21st day where the information is due is not due until February 7th.
They shouldn't have given him this court date is what it comes down to it.
Fast. Not to mention that we did have that snow week. So, Judge, I haven't done the intake on the
No,
case.
it's too quick of a turnaround. They shouldn't have given him this date. What's our next plea day? I'll do it that quick.
Can we do it in March, sir?
February 27th.
And the time?
1:30.
1:30.
Yes, sir.
Make sure you show up at your time. They shouldn't have given you such a quick turnaround date.
Yes, sir. I don't understand. I didn't understand that.
All right, thank you.
Thank you, Judge.
All right, anyone else?
I don't have anybody else out, Judge.
Got them set up? How many do we have at this point?
Judge Charles Russell, Public Defender's Office. This is Brett Andrus. He has multiple cases on the docket. For the record, it's 23 CF 2765, which is a VOP, 24 CF 756, which is another VOP, and then 24 CF 2157, which is listed as a VOP. And he's also on this afternoon's docket. That case number is 24 CF 2828. I'll deal with the newest case. That's here for felony plea day. State has filed the information. At this time on that case, we're going to go ahead and plead not guilty, request trial by jury, 15 days for any pre-arraignment motions. We would deny on the VOPs, ask that all cases be set for February 24th at 9. And I do have something to say about one of the VOPs, but I'll wait until the court catches up.
Okay, no, I've got them all. So
Okay.
February 24th. Is he at no bond on all the VOPs?
Probably, Judge. That's standard practice.
It's standard, but it's not 100%. What was your issue with the VOP?
Okay, directing the state and the court's attention to case number 24 CF 2157. It's listed as a VOP, but in looking at the plea agreement for the 3 VOPs, on 24 2157, they null-prossed the felony, gave him 11 months, 29 days jail concurrent on the misdemeanor, which was count 2, but there was no probation. And if you look in benchmark, I didn't see a VOP affidavit filed in that case because he's not in probation on that one. So I was going to ask if we can just close that case out or whatever we do with it to take it off the docket.
I had noticed something similar. In fact,
Is there a written plea agreement?
there was, and
It's-
it's
but
not
it-
very clear. It was done in the south end.
If you look in case number 23 CF 2765, the plea agreement is in there, and I want to say it was December 11th of 24.
Yeah, I can see that's when it happened. I just can't find the plea agreement. It wasn't in the case that you first mentioned, so I'm just trying to track it down.
I think they just filed it just in the 23 case, Judge.
Here it is, number 158. And the way I see 24 CF 2157 is count 1, the felony was null-prossed. Count 2 was 11 months, 29 days with credit for time served, so he's not on probation on 2157.
That's my position, Judge.
But was he adjudicated? Because they went and took a lot of trouble to specifically give him the withhold in the other two VOPs as a condition of probation to keep the withhold. So why would then he be?
Because
that was only a
This is
misdemeanor.
I got it.
He was adjudicated on the misdemeanors,
Yeah.
withhold on the felony.
That makes sense.
I think that was the plan, Judge.
I can understand it from what I'm reading. It just could have been a little more.
Yeah, Steve Medina said he kind of it was worded a little weird.
It just should have been separated out a little bit. It's just, you know,
'Cause it was supposed
for a semicolon that's in there, it's kind of hard to tell.
Yeah, because the way he kind of explained it to me was
I got you, Mr.
it was
Hammond.
supposed to be 2 1129 sentences, and then one I was supposed to have it.
The state's not going to go forward on 24 CF 2157.
Okay, so that VOP is dismissed. Otherwise, it was reinstate and modify supervision in 2765 and 756. So he's on probation for those two. And we're going to put everything on
224, Judge.
224. It'll ultimately be 226 if he's still incarcerated.
Correct.
All right. All right, thank you, Mr. Andrus. Mr. Russell?
Yes, sir.
Thank you.
Yes, sir.
Keem Calloway.
Judge, if I could have a moment. Judge, on Mr. Calloway's case, we thought we had worked something out, but at this time, he says he's not inclined to take the plea offer, so I guess we just need to put him on the 224 docket.
The state would be rejecting the offer to reduce count 1 to a misdemeanor.
Okay. What was the rest of the offer, just so it can be put on the record?
It was actually null pros to 1 felony, which was count 1, and then basically 180 days county jail on the misdemeanors, and then 60 days on the M2s, all of that concurrent. And concurrent with this, Mr. Calloway's actually in DOC custody on a Walton case. And so the plan was to give him basically misdemeanor time, make it concurrent to the Walton case too, but he says he wants to talk to an attorney. I had thought, based on the notes in the file, that Mr. Gibbs had already cleared all this with Mr. Calloway. Mr. Calloway is saying no, he doesn't know anything about it. So if we put it for 224, I can meet with him or talk to him and see what he actually wants to do. But I had warned him that there's a possibility that the state will withdraw the offer, and that's what the state is indicating today.
Understand that, Mr. Calloway?
Yes, sir. I was under, I ain't seen no attorney in 2 years. I've been in DOC, so this court date was like, it just popped.
We brought you back for it, right?
No, they brought me back on a whole nother case, a warrant that was served to me for the South End.
As I explained to Mr. Calloway, Judge, he was brought back on our order to transport in this felony case. There is a misdemeanor case pending in the South End. I am not on that case. I wasn't trying to bring him back for that case. I was trying to bring him back for this case because I thought we had a deal.
They booked me for the South End case and say I got to court on 2/18.
Okay, but that's in a different case in the South End.
That's what they said I was brought back to the county for. I ain't know nothing about this court date until this morning. I went to first appearance this morning.
You had a first appearance this morning?
So,
I think what happened is, Judge, when he hit the jail yesterday afternoon, they nabbed him on the warrant or the capias from the South End, and then that's why he had a first appearance, right? On that other case.
What type of charge is that?
I want to say it's a misdemeanor, criminal traffic, maybe?
no, driving.
Okay, so some kind of driving offense.
Okay. All right. What's that? Okay. Well, thankfully, there's at least a bill in front of the legislature about changing about how some of this works when someone's in DOC and has a pending case and how it can be potentially resolved.
So I was trying to get all of it handled.
Well, they're going to come out and talk to you, but the state's offer was to let you plead to misdemeanors for 180 days concurrent with what you're already doing, but it sounds like that was never conveyed.
It was never brought to my
That's what I'm saying. Conveyed means when they tell you what the plea offer is, so I'm just telling you the terminology that we use. So if I'm not telling the state what to do, but it sounds like it was never conveyed. So we'll bring you back on February 24th. Obviously, if you all work out something in the meantime, you can come back to an earlier court date to get it resolved. And how long is your DOC sentence?
Should be up in October.
Okay. All right.
Get my game time.
We'll see who gets resolved. And again, Mr. Russell, if y'all get it worked out, bring it in earlier than the February 24th date.
Yes, sir.
All right. Thank you, sir.
Charles Russell, Public Defender's Office. Judge, this is Joshua Carver. He has multiple cases on the docket. This morning, he has case number 2212, CF 1387, and 2013 CF 3024. Both of those are VOPs. And then he has a case scheduled for this afternoon, 24 CF 2943, and it's set for felony plea day. The state did file an information. We would go ahead and enter a plea of not guilty. If I could just have a moment, we may have a bargain to resolve all of them.
Okay, go ahead. Why is it that some that for arraignment today where you have date and some of them don't? You don't have February. Looks like you just got here. Seems like the second case we've had where someone got here. I think when I checked on Monday, he wasn't.
Judge may approach.
Yes, sir. Thank you, sir.
Record, Judge, Mr. Carver would be admitting the two VOPs. The state would drop the brand-new case in exchange for the sentence that's on there. Mr. Carver is concerned about his credit because he indicates to me that apparently he was arrested in North Carolina, which is where he's from, held on these VOP warrants for a period of time. Since we don't have documentation of that, I explained to him, you can't really give him credit till we get that. So I told him what we would do is, after the court imposes sentence, our jail will file their paperwork saying what credit he has here. If he has additional credit out of state, we're going to have to bring that later with documentation.
Ultimately, what he's pleading to is a violation based on the 2019 affidavit?
Yes, sir. Yes, sir. Yes, sir. Because I don't think another affidavit of VOP was filed listing the 24 case, the other case that's set for this afternoon. I think everything in the 19 affidavit is what we're admitting to.
There are accusations of moving to North Carolina and absconding.
I lived in North Carolina. I come here. I'm sorry. I came here on vacation, and I lived in North Carolina, and I bought stolen property when I was here. Stolen property, but I've never absconded. My address has been the same for the last 20 years. It's never moved on that situation.
Still want to go through with this plea that calls for 17.7 months in the Department of Corrections? There's new violations as well about new charges in North Carolina back in 2019 as well. Okay. Raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, I've been handed this violation of probation plea agreement for 12 CF 1387 and 13 CF 3024. It also includes 24 CF 2943, but the agreement calls for that case to be dismissed. Is that your understanding? Okay. Did you have a chance to go over this agreement with your attorney?
Yes, sir.
Did he answer all of your questions about it? Did you read and sign this paperwork? Do you need any more time to speak with him about this? Okay, it's a question I ask everybody. Are you under the influence of any alcohol, drugs, or controlled substances? Do you have any mental health issues or diagnosis? Do you understand what's going on here
Yes,
today?
sir, yes.
Do you take medication for it?
Yes, yes, sir.
Despite taking that medication, you feel that you're clear-headed enough to
yes,
look at
sir.
this today? Okay. Do you understand that by entering an admission to your violation of probation, there won't be a hearing where the state would have to prove that you violated your probation, and that you're waiving any potential defenses you may have to those violations of probation?
Yes, sir.
All right. And what is your plea? Are you admitting your violation or denying it?
Admitting the violation, sir.
Okay.
Can I ask my attorney one question?
Sure. And this is the state's agreement?
Yes, sir.
And it's a guideline sentence?
Okay, that
Hold on a second. All right, so this 17.7 is what he would have scored had he had the new case, but you've adjusted the guidelines to take that off, and he doesn't score at this point.
That's correct, but that doesn't change the state's offer.
I know. I just want to make sure that that's what
That's
we've
still,
got here.
Judge, is it your position that that's still the guideline sentence? Because my
This
understanding
is still a
is
guideline sentence. Guideline sentence means it's at least what
Anything-
the number is.
Yes, sir. It is.
If it's under it, then we have to talk about it being a downward departure.
Yes, sir.
But, okay. I just wanted to make sure because there were some changes that were done with whiteout tape or whatever, that everyone was under the same impression of what it meant. That you no longer score prison, but that's what their offer is.
Yes,
Do you
sir, I
understand that, Mr. Carver?
I understand that. That's why I asked about the downward departures right then, but he told me it didn't.
It doesn't need to be one because it's a guideline sentence.
Yes, sir.
Okay. All right, I'm going to accept your admission to the violation of probation in 12 CF 1387 and 13 CF 3024. State have an announcement in 24 CF 2943.
Dismissed, Judge.
Okay, that'll be now processed by the state. And the other cases will be adjudication of guilt, 17.7 months Department of Corrections on each count, concurrent to each other. They're all, well, yes, they're all felonies. Credit for time served, obviously, is, as your attorney mentioned, whatever credit you may have because you were sitting in North Carolina, they got to get that paperwork to us.
Yes,
I'm going
sir,
to give
that was
you,
the only thing I was concerned about.
Mr. Carver. We're going to give you all the credit that you're entitled to. I just don't know what that number is. So the jail's going to determine that, send it over to DOC, and then DOC will make that determination. If you have any further concerns about it, you can try to bring it back. But I don't know what any of those numbers are going to show me at this point. All right. Terminate probation, $250 PD fee, which is the $100 or $150. No.
Application and the $100 PD fee in one case, and then a $100 PD fee in the other case.
Okay, perfect. So total of $250, $200 cost of prosecution, all money obligations sent to judgment. Anything else?
That sounds right, Judge.
All right, step over, be fingerprinted. Mr. Carver, you have 30 days to appeal the judgment and disposition or sentence of the court.
Judge, if I might have a moment.
I got it, partially.
Judge, this is Bobby Joe Castleberry. Case number is 20 CF 3183. We've reached an agreement. This is a violation of probation, but we've reached an agreement with the state. If I may approach.
Yes, sir. Ms. Castleberry, can you raise your right hand to be sworn? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Did you go over this form with your attorney, Mr. Russell?
Yes, sir.
Did you have enough time to speak with him about that? Is this what you want to do today?
Yes, sir.
All right, let me take a quick look at it. All right, so basically it's a 180-day jail sentence, but she's going to be placed on probation in order to get the withhold.
Correct, Judge.
Got that right?
Yes, sir.
Okay. All right, ma'am, how old are you and how far have you gone in school?
I'm 26 and I've made it to the 7th grade.
Okay, were you able to read this document? Did you understand it all?
Yes, sir.
All right, are you under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Any mental health issues or concerns?
No, sir.
Did you have enough time to speak with Mr. Russell about this?
Yes, sir.
Did he answer all your questions?
Yes, sir.
Are you satisfied with his advice and representation?
Yes, sir.
Anyone force, pressure, or threaten you in order to take this plea?
No, sir.
Anyone promise you anything in return for your plea?
No, sir.
All right, you understand that by entering an admission to your violation of probation, there won't be a further hearing where the state has to prove you violated your probation?
Yes, sir.
And you're waiving any potential defenses that you may have had?
Yes, sir.
All right. And what is your plea? Are you admitting your violation or denying it?
Admitting it.
All right, I'm going to accept your admission to the violation of probation as freely, voluntarily, knowingly given. Continue to withhold adjudication, revoke and term your probation with a new term of 6 months of probation. Cost of supervision is to be waived. Condition of your probation is to serve 180 days. Okaloosa County Jail, credit for all time served. Probation terminated upon completion of that jail sentence. $150 PD fee, $100 cost of prosecution. All money owed is going to be sent to judgment. It's just a guideline sentence. Figures that it is.
Yes, sir.
All right. Anything that I've missed? Is that the state's agreement?
Yes, sir.
Okay.
Yes, sir.
All right, ma'am, you step over and be fingerprinted. You have 30 days to appeal the judgment and sentence of the court.
And Your Honor, probation is automatically terminated upon her release from the county jail?
Yes, sir.
And just for the record, we're waiving the supervision fees.
I did say that, but yes, just to make it clear, Mr. Berry.
Thank
Your Honor, this is Terry Chesser before the court on 24 CF 2084. He also has one for this afternoon, which is 24 CF 2890. We thought we'd reached an agreement on the one for this morning. We have not, so we're going to request to continue it and ask for it to track with the same court date that you give the one that's set for this afternoon.
Okay, which I believe is February 24th.
That would be fine, Your Honor. And we would,
And if he's still incarcerated, it'd be February 26th.
so it'd be February 26th.
Ultimately, is it?
Yes. And Your Honor, we would
Trying to get that
acknowledge.
separation so we don't have
Acknow-
500 and some people on the same day anymore.
We acknowledge receipt of the information, the charging document for this afternoon, the plea or attempt to elude and the violation of driver's license restriction. We're going to enter a not guilty plea at this time and request trial by jury and to be put on the 226 docket.
Yes. I think we're just calling it all 224, but they'll bring him on 226 if he's still incarcerated.
Still no chance for a bond.
That's not what we're here for today, sir. Didn't we talk about that recently? Yes.
Judge, if I could just have a moment.
It's all pretty black and white and blue. Appreciate it. Yes, sir.
Judge, this is Jeremy Cochran. He's before the court this morning on 23 CF 2573, which is a violation of probation. He also has a case scheduled for this afternoon's plea day, 24 CF 2908, states filed an information. We'd enter a plea of not guilty, but we do have a plea agreement that will resolve both cases. If I may approach?
Yes, sir.
And this will be a downward departure, Judge, for a negotiated plea agreement.
Okay. Thank you, sir. All right. Mr. Cochran, you raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. State your name and date of birth, please.
Jeremy Dwayne Cochran, December 14th, 1989.
Okay. And Mr. Cochran, you're here on 23 CF 2573, which is a violation of probation. 24 CF 2908, which is a new charge of possession of a controlled substance, third-degree felony. I've been handed a plea agreement for both of those cases. Have you gone over this with your lawyer?
Yes, sir.
Is this what you want to do today?
Yes, sir.
You understand it calls for 11 months, 29 days in county jail?
Yes, sir.
All right. Are you under the influence of any drugs, alcohol, controlled substances?
No, sir.
Do you have any mental health issues or concerns?
No, sir.
And did you have enough time to speak with your attorney, Mr. Russell, about this?
Yes, sir, I did.
And did he answer all of your questions?
Absolutely.
Did you go over the form with him? Did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
All right. Are you satisfied with his advice and representation?
Yes, sir, I did.
Anyone force, pressure, or threaten you to enter this plea?
No, sir.
Anyone promise you anything in return for the plea?
No, sir.
All right, you understand by entering a plea, there won't be a trial of any kind on the new case. There won't be a VOP hearing where they'd have to put on evidence to show that you violated your probation.
Yes, sir.
You understand you're giving up all your trial rights in the new case?
Yes, sir.
And those are discussed in this form that you said you understood?
Yes, sir.
All right. And you understand you're waiving any potential defenses that you have in either case? Okay. As to the old case, the VOP, do you admit or deny your violation of probation?
Yes, sir.
Admit or deny?
Admit.
Admit. Okay. And in the new case, what is your plea?
No contest.
Okay, I'm going to accept your admission in 23 CF 2573, and your no contest plea in 24 CF 2908 as freely, voluntarily, knowingly given, and 23 CF 2573, adjudication of guilt, 11 months, 29 days, Okaloosa County Jail on each count to run concurrently, credit for all time served, $150 PD fee, $100 cost of prosecution, revoke and terminate probation, all money owed to judgment. And 24 CF 2908, adjudication of guilt, 11 months, 29 days, Okaloosa County Jail, concurrent, which means runs at the same time as your violation of probation case. 23 CF 2573, credit for all time served, $100 PD fee, $100 cost of prosecution, standard court costs, which would be $615, all money owed to judgment. This is a downward departure. Looks like Mr. Cochran would have scored the lowest possible prison sentence of 22 months, but based on the plea bargain, it'll be 1129. Any questions about that, Mr. Cochran?
No, sir.
Is that what you understood the agreement to be?
Yes, sir.
All right. Step over your fingerprint. You have 30 days to appeal the judgment and sentence of
Yes,
the
sir.
court.
Appreciate it.
How many more do you have, Mr. Russell?
Two more defendants with one in between, that's Mr. Williams.
I just want to take like a 10-minute recess at some point just to make sure my legs still work.
Flexible, Judge.
Just whenever we can find a good break in between.
Judge, this is Terry Flores. Case number is 24 CF 1192. This is a felony violation of probation. One of her violations of probation is based on a misdemeanor that's pending with our office that has a arraignment date of February 4th. So what we'd like to do on the VOP that we're here for today is enter denial at this time, reset it for February 6th at 9 o'clock to see what happens on the misdemeanor case, and then maybe on February 6th we can resolve this felony VOP too.
1 second, Your Honor, if I may. I thought it was is it not a new case?
There is. It's a misdemeanor case.
No. The one we're here for, the 20, what is it? I'm just verifying. 24 CF 1192. That's a. Yeah. Okay. Thank you.
I've got it's a VOP.
No, I apologize. I had.
It's okay. All right, so Ms. Flores, we're going to see you back next week on February 6th to see what happens with your misdemeanor case on February 4th and see if they can get this resolved. All right, we'll see you then. February 6th, 9 o'clock.
What you want to do?
Charlie, I could go millions out of jail. I handled him earlier.
Judge, this is Denzel Green. Case numbers are 20 CF 2301 and 22 CF 1403. If I might have just a second.
Find out where we're at so we can just have a natural break.
You to sign there, and then I'll get her to sign.
Sorry.
Judge, I have a executed plea agreement and a score sheet if I may approach.
Yes, sir. All right, Mr. Green, can I have you raise your right hand? You swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Okay. Your name and date of birth, please?
Denzel Green, 09/19/1996.
Okay. Okay. I've been handed a violation of probation plea agreement. Have you taken a look at this? And did you go over it with your lawyer? Did you understand it? Did you sign it? Is this what you want to do today?
26, but I take 9.
Well, I can't negotiate with you on that, Mr. Green, so, all right. Are you under the influence of any alcohol, drugs, or controlled substances? Any mental health issues or concerns? Did you have enough time to speak with Mr. Russell about this? And did he answer all your questions? You satisfied with his advice and representation? Anyone force, pressure, or promise you anything for this? You understand by entering an admission to the violation of probation, there won't be a hearing where the state will have to prove how you violated your probation? You understand you're waiving all potential defenses you may have? All right. And are you entering an admission or denial to your probation violation? Okay. I'm going to accept your admission to the violation of probation in 20 CF 2301 and 22 CF 1403 on each of the felony counts, which would be counts 1 and 2 on 20 CF 2301 and count 1 of 22 CF 1403. It's going to be 270 days in Okaloosa County Jail, concurrent with each other. Credit for all time served. Count 2 on 22 CF 1403 is going to be 180 days because that's a DUI, so it's a specified traffic offense, which means that's the maximum amount that you can get for that kind of charge. All right, that'll also be concurrent, credit for all time served, $250 PD fee, $200 cost of prosecution, all money owed to judgment, revoke and terminate your probation in both cases. Anything that I missed? State's agreement?
Yes, sir.
Okay, and it's a guideline sentence. All right, Mr. Green, any questions? All right, step over and be fingerprinted. You have 30 days to appeal the judgment and sentence of the court. All right. And Mr. Russell, I think that's the end of yours.
That's the end of mine, Judge.
All right, we're going to take about a 10-minute break. We'll be right back. Thank you.
All rise, please.